Hello, we're back with Lisa Sowers and Jack Rosenberg discussing unemployment. Lisa, you were a hearing officer, so I would imagine you saw a lot of cases where you say, I wish you were doing this differently. What sort of suggestions would you have for somebody to present a case? What kind of evidence, what would affect their credibility with you?
When judging credibility, one of the most important things is to just answer the question that's being asked, but make sure you answer the question. And while that may seem very simple, people have a tendency to second guess what the hearing officer is thinking. And they think, well, the hearing officer is not going to be happy with what I'm saying, so I'm going to give them the answer they want to hear. And hearing officers can sense that. If you're avoiding answering the question, if you're answering anything but the question, you come across as evasive, and that affects your credibility.
Okay.
When it comes to incidents where other people were involved, you should always bring witnesses that have firsthand knowledge.
Can I bring affidavits?
You cannot bring an affidavit. People oftentimes come in with notarized affidavits. The tribunal views them as hearsay. They are inadmissible. So that essentially is a waste of time unless you have the witness with you at the hearing to testify to what's in their affidavit.
Okay. Jack, anything else that you would like to see folks bring to the hearing?
Sure. And to add what Lisa said, sometimes when we want to have a witness to testify at the hearing, they're at work and they can't get off. And there is a provision that allows for telephone testimony where someone could be called during their break or lunch period as available. So you want a subpoena, you can get a subpoena for that witness to make sure they're available, but they don't necessarily have to attend the hearing if you can make arrangements. The other thing is that any documents that you may need from the employer, you have the right to subpoena those documents. So you should either bring them or subpoena the documents that's involved. One other thing also is that, let's say you had some injury on the job that may have involved workers' comp or may not even have involved workers' comp, such as a medical issue. Let's say you had a medical issue that kept you out of work. You need to bring those medical documents because those can support your being awarded unemployment if the illness was of yours or a family member, for example, and you notified the employer that your absences were because of a personal illness.
All right. Now that you mentioned workers' compensation claims, Lisa, I mean, that doesn't automatically disqualify somebody from receiving benefits if that person is not receiving what they call temporary total disability payments and workers' compensation.
That's correct. So long as they're not drawing workers' compensation, you cannot draw unemployment benefits and workers' compensation at the same time. They can get unemployment benefits.
All right. Yes, Jack, go ahead.
I was just going to add one thing, that I often assist a number of workers' comp attorneys who have filed workers' comp on behalf of their client. The company is fighting that whether or not it was a true workers' comp injury. And it's very vital, and a lot of people don't understand. Go ahead and apply for your unemployment. You can't work, and you need to get your unemployment. Now, there is one other point. If you are so physically unable to work whatsoever, you're not eligible for unemployment. You actually have to be able to at least sit at a desk, answer the phone. You may not be able to run a machine or to dig a ditch or whatever, but as long as you're able to work, you can get unemployment.
Well, at that point in time, you probably have to apply for SSDI, you know, but that's a good point. Now, Lisa, and we haven't spoken about this yet, but that person, while receiving unemployment benefits, has some responsibilities to look for a job.
That's
right?
correct. You have to be able, available, and actively seeking unemployment. What that means, you're bona fide in the labor market. You have to actually keep a record of your job search. I believe the department requires at least 3 contacts a week. Mm-hmm. That doesn't necessarily mean that 3 resumes had to go out, but you had to have made at least 3 contacts a week.
Right, and you have to report those.
You do. They actually give you a green sheet when you apply for unemployment that you have to fill out, and if you can't provide that when it's requested, you could potentially lose your unemployment benefits.
Okay. Go ahead, Jack.
Yes, I was just going to add one thing that we talked about in the earlier segment, and that is that while the hearings are somewhat informal as to setting, they really are legal proceedings.
Right.
That the hearing itself is really the ball game. Under the rules, you need to present everything you have, your evidence, your witnesses. A lot of people will mistakenly think, well, I'll do the best I can at the hearing, but I always have the right to appeal. But it's sort of like a trial court and then the appeals court. If you don't get all that evidence in, you can't present it later at a later proceeding.
Right, and you do have the right to appeal, Lisa, right? If you're
do.
dissatisfied with your decision.
That is correct. Either party can appeal within 15 days of the day the decision is released. You want to pay very close attention to the deadline to appeal. Beyond the deadline, you're going to have a very hard time appealing your case.
And what are you appealing to?
At this point, you are going to be appealing to the Board of Review, which is within the Department of Labor.
And if you're dissatisfied with that decision, you go to?
That's correct. You can appeal that. You then have 30 days to appeal it, and it would go to the Superior Court in the county where your employer's place of business is located.
Right. And Jack, once you get in the Superior Court, of course, you can continue your appeals to the Court of Appeals, Supreme Court, if necessary.
Right. The good thing is that when you do go to Superior Court, you can ask for a hearing, and you can bring up a number of points. However, not to get too technical, you won't be able to argue evidence again. You'll only be able to argue whether the hearing officer made a decision that was against the law, a matter of law, not a matter of facts.
Right.
And once that, if you were to lose at Superior Court, you have Court of Appeals, which is a discretionary review, and the Court of Appeals rarely grants those.
All right, 30 seconds, Lisa, because we don't have a lot of time. If a person is an independent contractor and let's say in the trade businesses, and he can't find a job, how long does he have to go without, because there's no jobs out there? Let's say that you work, you have a little job working as a carpenter or something.
Okay. An independent contractor may be termed an independent contractor by their employer, and they may in fact be an employee. So what they need to do, if you are classified as an independent contractor, but your employer is supervising your work, you should go to the Department of Labor and ask for a liability determination.
Okay.
And it will be determined whether or not you can.
It'll be a ruling.
Right, will be made.
Be entitled.
Yes.
Okay, well, I want to thank both of you. Unfortunately, we're out of time, and come back and talk to us about this some other time.
Okay.
So, thank you. We'll be back next Sunday at 10 o'clock in the morning. Until then, y'all behave.
La estación transmisora WPBA no tiene licencia para practicar leyes en el estado de Georgia. WPBA y los patrocinadores de este programa no son responsables por las opiniones expresadas ni la información proporcionada por los abogados en este programa. Este programa se ofrece como un servicio público. El objetivo de este programa es de informar y educar y no de proveer consejo legal. Si usted necesita consejo legal, favor de consultar a un abogado. Leyes Cotidianas les llega a ustedes gracias al generoso apoyo financiero de la Fundación de Justicia Civil del Estado de Georgia. Mundo Hispánico, el vocero de la comunidad hispana desde 1970.